the construction industry. It has a vision to have a thriving and sustainable African construction industry. Its mission is to bring together experts and professionals in advancing best practices in the construction industry through training, advocacy, and research for the benefit of all stakeholders. We are welcoming you to join the Institute if you are a professional in the construction industry. We are calling upon engineers, we're calling upon architects, surveyors, lawyers, contractors, and experts to join us. For further information on how to do this and any other information you would like to find out about the Construction Law Institute, please visit our website on www.constructionlawinstitute.com. To discuss our topic of the day are two distinguished speakers. Our first, Anne Namara Musinguzi, who is a founding and managing partner of Namara Musinguzi and Co-Advocates, a boutique law firm specializing in arbitration, construction law, and corporate governance. She is a member of the Chartered Institute of Arbitrators and the chairperson of the Education and Training Committee of the Uganda chapter. She is also the editor-in-chief of the Chartered Institute of Arbitrators Uganda chapter quarterly newsletter. She is a director and head of faculty in the Construction Law Institute. She is also an editor-in-chief of the Construction Law Institute Yearly Digest. Anne Namara Musinguzi is a thought leader in the areas of construction law and arbitration through writing articles and participating as a trainer and panelist in trainings organized by the Chartered Institute of Arbitrators, the International Court of Arbitration of the International Chamber of Commerce, the Construction Law Institute, and Uganda Law Society. Anne sits as an arbitrator as a sole arbitrator and also as a panelist on various dispute boards. Please welcome Anne to this webinar. Anne, you're welcome.
Thank you very much, Philip. Good afternoon, good morning, good evening from wherever you're joining us. I'm honored to be part of this panel and looking forward to a very insightful discussion.
Thank you. Our second speaker, Mr. Ivan Okuda, is a fellow of the Chartered Institute of Arbitrators. He is a legal associate at Anguria and Company Advocates. He specializes in construction law, energy, and arbitration. He holds a Bachelor's of Law from the Makerere University, a postgraduate diploma in legal practice from the Law Development Center, a Master's of Law in Construction Law and Arbitration from Robert Gordon University, Aberdeen, Scotland, and a Master of Arts in Journalism and Media Studies from University of Witwatersrand, Johannesburg, South Africa. He is a fellow of the Chartered Institute of Arbitrators and has represented clients in cross-border energy and infrastructure projects, including acting as lead counsel in international construction contract disputes under the International Court of Arbitration of the International Chamber of Commerce. Mr. Okuda, you're welcome. Thank you for joining us.
Thank you, Mr. Philip Kahero, and very good afternoon from Nakasero, Kampala to the esteemed attendees of this webinar. Thank you.
Thank you. Now, we have been hearing of cross-border construction contracts And we're wondering, what is this? And may you help us and tell us, what is a cross-border construction contract? And what circumstances would we need to determine its use?
Thank you, Philip. Good afternoon once again. Cross-border construction contracts, like the name suggests, are contracts that cut across borders. So one of the key features is that they must be in two different jurisdictions. For example, if Uganda wants to work with the DRC to make immigration seamless at the Mpondwe border post, then they will execute a cross-border construction contract with DRC. The projects usually handled by cross-border contracts are large projects, and they should serve the common good of both countries. And to put this in context, it's good to look at some of the cross-border projects, both finished and still in the system, and then you will understand their why. I started with Mpondwe, the cross-border post at Mpondwe. Mpondwe is the border between DRC and Uganda. So it's one of the cross-border posts that were put up. There's one at Mirama. There's another one in Kapchorwa. And they serve to make, like I said, immigration very seamless. So if you're crossing over from either Rwanda or Uganda, you should be able to have your check-in and your verifications in one place without having to go through the hurdle of going through many places. So that is one of their use. They just make services better for the community. I would also give an example of what we popularly call the Mpigi Busega Road. It's actually one that runs up to Rwanda. So traders will be able to move effortlessly. They shall be able to sell their goods effortlessly, and all the people around the path of the project shall be able to benefit. The community will benefit, the ladies shall benefit, the children shall benefit, persons selling different things shall benefit. So to answer your question, Philip, the use of a cross-border project is used in circumstances that make the lives and livelihood of communities better. We have the Elegu border market, which was flagged off recently, sometime in June. So there is that market at Elegu. It's the border of Uganda and Sudan. It's at Nimule. It's a very vibrant market, but it has a problem. It faces a challenge of floods. So this market is called a climate market. It's a climate-friendly market. So they are solving a problem of flooding. Actually, the problems they're solving are two in one. They're solving the problem of climate by controlling the flooding, and then by ensuring that people are able to trade and have no problems and challenges caused by flooding and all other climatic factors when trading. I hope I've answered your question, Philip. Over to you.
Thank you, Anne. Thank you. Thank you so much. You have highlighted a few benefits while describing what cross-border construction contracts are. May you kindly elaborate more on what other benefits we may have by using construction cross-border contracts? Anne?
Yes, Philip. Like I mentioned, it's for the advantage of the community. People will get jobs. For example, under ECOP, we are all familiar with the ECOP project and also the SGR project. There are certain jobs that have been restricted to nationals of either country through what we call national content. So we have the economies of the countries growing and livelihood of people getting better because of the cross-border projects. And then we also have international infrastructure corridors for long-haul traffic, like I mentioned, the Mpigi Busega Highway, and how it's going to help in making transport seamless. And also, it also helps with the easy flow of people from one border to another. We are part of the EAC, the East African Community, and we are pushing for integration. And one way of integration is to have these cross-border contracts and projects. We are also pushing as Africa for the Africa Continental Free Trade Zone area. And one of the things under the AfCFTA treaty is to have seamless movement of people and of goods from one African border to another. So that is what we're working at, and cross-border, there's no way of ensuring this unity and uniformity rather than through cross-border projects. But they also help in development. Imagine if there's a need to be solved and there is not enough funding or goodwill, having a cross-border project would solve that problem. Thank you.
Thank you, Anne. Still staying with you, what legal provisions should we allow for these cross-border construction products to be effected?
This is where the lawyers are listening very hard. And I hope I don't burst their bubble by telling them that there is no one size that fits all. These contracts are all peculiar and they all have different legal provisions. For example, EACOP, the pipeline, the governing statute is the EACOP Special Provisions Act, Cap 156. Now, under that act, section 12 of the act will tell you that it is governed by the host agreements and all other laws of Uganda. So the other laws of Uganda will include things like the land. Now I'm speaking from the side of the Ugandan part of the border. The Land Acquisition Act, when you are acquiring land for the pipeline, you have to compensate people. When you're employing people, you're bound by the Employment Act, you're bound by all the laws governing labor relations in Uganda. You're bound by the Occupational Safety and Health Act. You're bound by the NEMA Act because there are also environmental assessment consideration. So you will usually have so many laws on a project. There are agreements between the governments that are known as the host government agreements. There are agreements. No, the agreements between the government are the intergovernmental agreements. There are also host government agreements between a government and a service provider. For example, EACOP has a host government agreement with Uganda. There are off-taker agreements. These are for people who undertake to buy the product that is a subject of the transaction. There are loan agreements. There are different funders, ADB, World Bank, Danida. There are different funders and they will also have different agreements. When you hire contractors, the FIDIC forms of conditions of contract will apply to some projects. For example, in Uganda, SGR recently signed with the contractor. And the contractor is their relationship is governed by the FIDIC White Book. So it's a turnkey. It's a condition of contract, FIDIC contract, meaning what the contractor is supposed to do is to execute the project and give it to the Ugandan government, who shall be able to implement it at the turn of the key. There are concessionary agreements that are signed. There are operation and maintenance agreements that are signed. There are term maintenance contracts that are signed. Mpigi Busega, now the Rwanda bit of it is going to sign a term maintenance contract once this is done, meaning that they will pay the contractor to continue to manage the project even when it is done. There are production sharing agreements. There is the East African Community Treaty, especially for these cross-border posts, the COMESA Treaty, the Customs Union Protocol. Specifically for the cross-border posts, there is the ESC One-Stop Border Act of 2016 that also lists how the border posts should be controlled, who is in charge where, what happens where there is a challenge. So there is no one legal framework, no one size that fits all for all these projects. It's on a case-by-case basis, and it's usually a whole spectrum of things. Because as you take out the loans, if you have funders, you will need agreements. As you engage all these other service providers, you will need agreements. Like EACOP clearly stated, you're bound by the laws of Uganda. You have so many agreements that are used. So that is the legal regime. It's not one size fits all. It's dependent on whatever on the project.
Thank you so much, Anne. What should parties do to ensure smooth execution of these cross-border construction contracts? Yes, if you could just touch on that, please, before we bring in Ivan. Thank you.
Thanks, Philip. Now, ensuring smooth implementation starts from the beginning. It starts from the time you moot the idea that we want to have a cross-border projects, even before you do an inception report. While you are doing feasibility studies, you need to sit down and consider, because remember, these are two different countries and they each have their own set of regulations. You are dealing with conflict of laws. You're dealing with so many differing legal regimes. So it is at that point in time that you sit down and agree on so many things. You agree on taxes, you agree on insurance, you agree on who does what, the obligations of the parties, you agree on who bears which risk. So it is at the time of feasibility, when you think about the project, is when you deal with all the scenarios. You agree on what the mode of dispute resolution will be. Will you go for litigation or will you go for alternative dispute resolution, as Ivan will later discuss? So all those things are discussed. And when you have agreed, you agree on funding. Are you going to get funders? Is it going to be a hybrid of funding and counter financing? How exactly is it going to work? When the project is done, who is going to manage it? Is it on a build, operate, transfer? What condition of contract will govern it? Will the contractor is the contractor supposed to just hand over the project when it's done? Will they have, is there any PPP? So all those things are agreed at the time of inception, and they are reduced, and it's usually committees from both countries. They will reduce all their findings into a report. It is only when the report makes business, economical, and political sense that the project will then go ahead. So, in order to ensure a seamless or a nearly seamless cross-border project, at the inception, during feasibility, you have to answer. All the tough questions have to be tabled and they must be answered. And then the parties will decide whether they are going to work together or not. You don't want a scenario where you are in the middle of the project and you haven't provided, for example, for price variations or price fluctuations, and the situation has arisen, or you haven't locked in some clauses and the taxes are flying all over the place because there was no lock-in clause. So all those issues are handled at feasibility, and then the parties make a decision as to whether to continue or not. Force majeure, you'll speak about force majeure. What happens if there's a change in government? Because we've seen these things happen. What happens when somebody has challenged a decision of one of the countries? What happens? So all those things should be agreed upon, and if they are, and if all the risks are anticipated and provided for, then the project shall be a success. Thanks.
Thank you, Anne. I'd like to ask Ivan if there's anything you'd like to add on to that particular question.
Thank you, Philip, and thank you, Anne. Just to, by way of supplement, to share the fact that it's very important to have clarity around the project delivery risks and jurisdictional risks, which essentially come into play in cross-border projects, but also international construction contracts, and what some people prefer to call transboundary projects. So typically, project delivery risks are risks that relate to the delivery of a specific project and to the financing and construction aspects of that project. So you're looking at things like counterparty risk, site risks, ground conditions, and all those nitty-gritties that come into play when you have a fairly complex and intricate project in the picture. So on the other hand, jurisdictional risks are risks that relate to the jurisdiction within which the project is being executed or being delivered. you'll have governing law issues or challenges. You'll also have issues around enforceability of adjudication decisions and arbitral awards. In some jurisdictions treat adjudication differently from the others. In the UK, for example, you have adjudication which is statutory, provided for by the Housing Grants and Construction Act, later amended by the Local Democracy and Development Act. In many parts of Africa and the Middle East, adjudication is not statutory. So that presents a very serious challenge in terms of how you enforce a decision, for example, of a dispute avoidance and adjudication board, if one party decides to act with impunity. And then also you have issues to do with enforceability of arbitral awards. Some countries, including in Africa, are not signatories to the New York Convention on recognition and enforcement of arbitral awards, 1958. So you've got to be very careful how you navigate around those intricacies. But I think that ultimately what matters in terms of the smooth execution of projects of this nature is to have very robust mechanisms that address issues such as cultural differences, communication barrier, how an Arab communicates something on a construction site or in a site meeting as a contractor will be different from how a Ugandan communicates, and that communication or cultural difference can affect project delivery. You also have issues to do with government relations. I interacted with a company that executed the project that involved Uganda and Tanzania. The Ugandan part, things appear to be moving faster than Tanzania. Because remember, if you're doing, for example, a hydropower project, you possibly need not less than 10 different types of power. So if you're doing that in Uganda, you have to do the same for Tanzania. Tanzania might be slower than Uganda in some respects. The equivalent of NEMA will probably drag its feet, and then that will slow the progress of the project. Sometimes there might be a difference of opinion in terms of how the tax authorities in the two different jurisdictions treat different aspects of the tax components of the project. And the labor laws might also be different. There might be local content requirements in terms of the suppliers and subcontractors in Uganda, which might be different from Tanzania, for example. So government relations are very important. Someone who was involved in that project told me they went in as a contractor and left as a diplomat, because you're dealing with high-level officers in two different countries, and the kind of language you use in lobbying for different things to ensure that the project moves smoothly, is a very interesting thing. I think on Monday I had a discussion with an investor who wanted to develop a hydropower plant of about 50 megawatts between Uganda, Tanzania, and Rwanda. So on River Kagera, you've got a very good site called Nshongezi, which can generate up to 60 megawatts of electricity. But for you to pull off that project, you need to have the government of Uganda, government of Rwanda, and government of Tanzania on board. In fact, there is a tripartite agreement among the three countries. So imagine as a private party having to juggle across three different jurisdictions. Sometimes the Rwandese and the Ugandans might wake up on the wrong side of their bed, and the diplomatic relations have gone sour, as it has happened in the recent past. And you can't have flights between the two countries. Probably the government officials from the two countries can't speak to one another. And then as a contractor in that mix, you really can end up getting in a big mess. Lastly is the complexity of these projects is that there's so many actors and small things and parts moving in the ecosystem. So one of those, from my experience, has been the question of subcontractors and suppliers. If you have a cross-boundary project, or let's even say an international construction contract, you certainly, chances are high you're going to work with subcontractors in the jurisdiction where the project is being executed. And I can tell you, if you've got to be very careful which kind of subcontractor you want to get in bed with. If you get in bed with a subcontractor with whom you're going to pick up a fight, that fight can end up screwing a project. I've seen that happen in a project where I'm involved as a council. I can't give the details, but between the contractor and the subcontractor, a project of almost 100 billion shillings, a dispute arises, and that dispute could not be resolved amicably. Eventually, the contractor had to terminate its contract with the government of Uganda because of that legal dispute with the subcontractor. So, I mean, this it can get really messy. So you've got to have very clinical approach to who becomes your subcontractor, because subcontractors can be make or break for this kind of projects. Thank you.
Thank you, Ivan. Thank you so much. You have, yes, really exhausted on that question. Somebody started as a contractor and ended up as a diplomat. Yeah, I wouldn't want to say jack of all trades, but it's good to know that people have multiple hats that they put on in order for the smooth execution of a project, in order to make it completed or to get it finished. You mentioned in your answer something about disputes. What is that, Ivan? What is a dispute?
Okay, a dispute in the construction sense of it is not really different from how you define a dispute in any other sense, whether it's in family law or land or labor rights, whatever field of law it is. A dispute is a dispute, only that in the construction law, there's a bit of more nuance to it. So typically you have a conflict that arises, contractual terms between the parties have not been met. This could be things like delayed payments. I'm involved in a project where, just as a way of example, contract executed in the year 2015. This is now 2025. 10 years down the road, the contractors had to have no cost extensions over the last 10 years because the Minister of Finance releases money in drops. So where in the financial year, the contractor is supposed to be, advanced, say, 1 billion shillings, the Minister of Finance releases 200 million shillings to the government entity that is a party to this contract. What that delayed payment means is not just a delay on project completion, but a serious dispute, because delayed payments are a very serious component of the dispute. As Lord Denning put it in one of the cases in the 1970s, cash flow is the lifeblood of construction projects. So if cash flow is constrained, the nature of construction contracts, whether the United Kingdom is called the Joint Contracts Tribunal, or the new engineering contracts, whatever standard form of contract you want to call it, those contracts have inbuilt mechanisms to ensure that cash flow, as the king of the project, is not suffocated. If that suffocation occurs, then you have a dispute, which of course entitles the contractor to different remedies. Disputes could also arise from delayed schedules. I'm familiar with the project, which is an ongoing dispute. Again, I can't go into the details, but I know it's now at the adjudication where a site possession certificate is given to the contractor, and 1, 2, 3, 4 months down the road, government bureaucrats are simply speaking a lot of English, and the project just can't take off. Financing is available because the project is funded by one of the multilateral development banks, but for some reason, site possession can't happen because the government, for example, has not compensated landowners. So that delay in terms of allowing the contractor to be able to start work, of course, impacts quite significantly on their labor, which is already mobilized. It impacts on their cash flow because they've gotten, they've had to secure guarantees, and those guarantees are secured. So basically, in the ecosystem that the project is, there's so many little things that that can happen and become a dispute which can be resolved, as we shall see later. Thank you.
Thank you so much, Ivan, for that definition and for that explanation. Now that we have talked about the challenges that cross-border construction projects or disputes might face, Anne, may you help us? What do you consider would be the possible remedies or solutions you would propose to mitigate these challenges?
Thank you, Philip. As I stated in my earlier talk, when you're doing your feasibility study, you should be able to envisage that there is a challenge that will arise, and you provide for a remedy or a mechanism on how to deal with it. Another way of ensuring that you curb these challenges is through the use of alternative dispute resolution, providing for it in your contracts. And when I say alternative dispute resolution, or ADR, I'm not speaking about arbitration only. I'm speaking about the whole spectrum. I'm speaking about negotiations. I'm speaking about mediation. I'm speaking about the use of dispute avoidance and adjudication boards. I'm speaking about the use of the dispute boards. All those are mechanisms. And the one that is really, the two that would really be preferable, the ADR mechanisms. First of all, there's the negotiation one, when the parties come to the table and try and reach a conclusion without the involvement of a third party. Most appropriate would be the use of DABs, dispute avoidance and adjudication boards. And the DABs are not set up when there's a dispute. The DABs are set up at the commencement, and they work with the parties all through. They're bound by rules. The adjudicators are bound by rules. They have an agreement. They're bound by agreement between the parties, and theirs is to ensure that if a dispute arises, the same is nipped in the bud before it gets out of proportion and the parties go to arbitration. Remember, these are two countries. There's lots that is happening. Political relations need to be preserved. The taxman is wondering what is happening. The citizens of the countries are wondering what is happening because this is their money, taxpayers' money. So you don't want a situation where political relations are strained or where the project comes to a standstill. So the DABs would be the best thing to do to nip these disputes in the bud. The DABs, a three-member dispute board is ideal because they'll be from different professions and they'll know what to advise on. But even one member can do it. So in order to curb these disputes, you have to explore the entire ADR spectrum. I would like to give an example of the FIDIC conditions of contracts 2017. Even when they provide for the DABs, they provide that the parties can still informally meet and settle this matter, or they can informally call on the DABs to give a decision, which is very informal and non-binding. If they sense that a dispute is about to arise, they can call on the DAB to handle it, and they give a very informal matter. But even when a dispute has arisen and the DAAB has given a decision, if any of the parties is dissatisfied, they are not supposed to go to arbitration immediately. FIDIC 2017 mandates that they still have an informal discussion with a view of trying to settle the matter. It is when the parties fail to settle the matter that they can then proceed to arbitration. Of course, there are timelines. And all this is done, as I've said, to preserve relationships. If everything still fails, then arbitration which should be in the contract or agreed upon by the parties. And I'm speaking about international arbitration. Like Ivan said, there's conflict of laws. There are different laws, and so there is nobody who is going to be willing to have their law not applicable. So in such scenarios, it would be good to use international arbitration and the laws governing it to resolve the dispute. Thanks, Philip.
Thank you, Anne. You have talked about the alternative dispute resolution, ADR, and the various types of ADR mechanisms that are available. I wanted just to find out, how are these, you may have touched on it, but maybe just to confirm that we don't skip over it. How are these affected? You mentioned DAAB. How are these ADR mechanisms affected in the cross-border construction contracts?
Thank you, Philip.
Yes.
Sorry. As I mentioned, they should be provided for in the contract. In the different contracts, remember in the beginning, we said there's a broad legal regime, and whatever legal regime is there should provide for this contract, for these ADR mechanisms. And the most appropriate way to do it is through what we call a multi-tiered dispute resolution clause, where the first tier of dispute resolution is a negotiation between the parties. And if that fails, then the parties can go on to mediation. And if that fails, that is when they can go to arbitration. But like I said, if DABs or DABs are used and are used properly, they are also a perfect mode of dispute resolution. But all those things must be in the contract. If they're not in the contract and a dispute arises, then the parties also have the liberty to opt for them, because ADR is based on, all ADR is based on party autonomy. So the parties can agree and say, okay, fine, we can have the mediators, or we can have the arbitrators, or we can have the negotiations. But if for less conflict, it would be great to have a perfectly drafted arbitration dispute resolution clause. The danger is when the dispute resolution clause is drafted haphazardly. And when the dispute arises, then that's when the parties realize that they don't exactly know what to do to resolve it. So at the time of drafting all these contracts, at the time of doing the feasibility studies, the parties should be in sync and say, look here, none of us is going to agree to use the other's laws. So let us opt for these international mechanisms of ADR. They will help preserve our relations. The projects will still go on, especially when you're using the DABs. That doesn't mean the project stalled. So the project will still go on as the parties resolve the disputes. The DABs will monitor the whole dispute from beginning to the end. I mean, the whole project from beginning to the end. And like I said, try and nip any disputes in the bud. So the contracts, the various contracts are the first, are the starting places. I'm aware of some of these contracts, of the legislation that is that provides for modes of dispute resolution. For example, the One Stop Border Act of 2016 provides for its own mode of dispute resolution. You apply to the Council of Ministers. If a dispute arises, if you are not happy with the decision of the Council of Ministers, then you go to the East African Court of Justice. The parties that are using the African Continental Free Trade Treaty also have their own mode of dispute resolution that is provided for in that treaty. They have what they call dispute settlement panels. It's an either or. If you do not want to use the dispute settlement panels, then you can use the arbitration. Dispute resolution under the treaty is very interesting because whoever is dissatisfied with the decision of either the dispute settlement panel or arbitration can appeal. There's an appellate body that will handle, that will review decisions. It's interesting because it goes against the principle of finality of arbitration, as we know. But in the absence of a statute specifically providing for a mode of dispute resolution, we propose that the parties agree in the contract, and the agreement must be premised on preservation of relationships. And like I said, with international arbitration being the last course of action. Thank you.
And you have touched on members to boards, dispute avoidance and adjudication boards. We have spoken about disputes arising and touched on how they can be resolved. But who resolves these? And we realize that people, experts, or non-professionals would be part of what we would call dispute resolvers. So, Ivan, I would like you to enlighten us on how are members appointed as dispute resolvers in cross-border construction contracts, and tell us how many should be appointed on these as dispute resolvers. Thank you.
Thank you, Philip. Maybe just let me make a rider or a qualifier for the benefit of the listener. The crux of the discussion on cross-border projects or construction contracts will largely make a lot of reference to standard form contracts. And because there are not so many such projects which are trust-boundary, it might be a bit out of touch for many people. But just for their comfort, is to say that the governing contract framework for cross-border projects will pretty much be the same governing framework for international construction contracts. Question then is, what's the difference? Is there a difference between an international construction contract and a cross-boundary contract? Just by way of example, the Ministry of Health of Uganda has a project in Mulago, which is ongoing. It also has another project under the Uganda Heart Institute in Naguru, a project for which, as citizens of Uganda, we should all be proud, because it's going to be a center of excellence for heart treatment in Eastern Central Africa. I've seen the designs and the impression of that project. It's a fascinating piece of work. Now, the project in Mulago is a domestic construction contract. The project in Naguru is an international construction contract. What makes this one domestic and the other one international? Same city, possibly 10 kilometers apart in terms of distance between Mulago and Naguru. Same employer in terms of the government being the employer, stroke the client, stroke the owner of the project. The Naguru project under Heart Institute is a project that has an ecosystem which brings on board different nationalities. In other words, what is crossing borders is not necessarily the physical geographical border, but you've got capital crossing borders, capital meaning human capital, because you have an international contractor. So that international contractor brings international expertise, given the fact that it's a highly specialized field of construction, because you're building a very specialized hospital facility. You probably have, if it's a standing dispute avoidance and adjudication board, you have that board being constituted by people from outside Egypt and Uganda, Egypt being the country of origin of the contractor. Then you have equipment, machinery, and whatever installations are going to be put in that facility coming from different parts of the world, Germany, USA, India, and all these places. The funding for the project coming from a multilateral development bank, such as the Islamic Development Bank. So all those actors in the ecosystem are drawn from different nationalities, and that's what makes that an international construction contract. The other side in Mulago, it's typically Ministry of Finance financing this project from government of Uganda budget. The contractor is a local contractor. The subcontractor is local. There's no importation of construction material. It's basically a simple project. Therefore, it's not complex enough to warrant the participation of actors from different parts of the world. So the Naguru project will most likely, or a project of that nature, will most likely be governed by the FIDIC form of contract. And chances are high that you will find that type of contract governing a cross-border project like the ones that my colleague Anne has deliberated on. I'm saying that just to give comfort to parties that, to participants might look at the idea of cross-border projects as a bit far out of reach. So back to your question on dispute resolvers. So the nature of again, FIDIC, because it's the most popular standard form of contract for international construction contracts in the way that I've explained, or cross-border construction contracts in the way that the examples that Anna has given. So a lot of reference is made to it. In the United Kingdom, FIDIC is not the most popular of them. In the Middle East, quite popular, especially in Dubai for their construction projects. So for the purpose of benefit of the discussion, let's look at FIDIC as the gold standard, because it is the gold standard. Of course, the British won't accept that. So under FIDIC 2017, which is a revised edition of the 1999 Red Book, under clause 20, you have, like what Anna has described, a multi-tiered dispute resolution mechanism. In other words, it takes cognizance of the fact that a project has so many complex things moving, and to keep it on course, you ought to build a sort of pyramid that has different levels of dispute resolution. So the first, at the bottom of that pyramid of dispute resolution, is what is called an engineer. Some people would prefer to call that person or that entity, could be a company, a project neutral. So the project neutral is it's a professional, chances are high, an engineer or a quantity surveyor like you, Philip, an architect, or someone in that field. Certainly not a social scientist, because these are complex projects that need very specialized expertise. So that engineer, in and of himself or herself, is a dispute resolution mechanism under the FIDIC form of contract. How? If there is a dispute between the contractor and the employer being the owner of the project or the client, the first point of recourse is, or usually that engineer. That's so the party that has a dispute will, in 28 days after becoming aware, or should have become aware of the dispute, register that dispute with the engineer, who is given a strict time frame within which to have that dispute resolved. The dispute could be on something as a change order request. There's a project, again, a Government of Uganda project, where the contractor, midway the project, at about 20 or 25% execution, said, we think that the detailed design of this project was wrongly done. You got so many things wrong. We think that we need to revise the contract amount by $10 million, and then the Government of Uganda is upbeat about that and can't take it. So that dispute would ordinarily first be resolved by the engineer. Now, if the contractor or the employer is dissatisfied with the decision of the engineer, then you refer it to the Dispute Avoidance and Adjudication Board. The Dispute Avoidance and Adjudication Board will then look into the dispute, and if one of the parties is dissatisfied with the decision of the Dispute Avoidance and Adjudication Board, which, by the way, does not have time at large to make its decision, there is a very strict time frame within which you ought to have made that decision as the DAP, then the dissatisfied party files what is called a notice of dissatisfaction, say within 15 days, and then that matter can find itself to the arbitral tribunal or be referred for arbitration. So why is, so the engineer is appointed by the employer and paid by the employer. Quite a contradiction. I know that scholarly debates around that. You'll find a lot of debates on whether the engineer can still remain independent despite the fact that he is appointed by the employer and paid by the employer. Of course, the overriding obligation on the part of the engineer is to be professional, neutral, independent, despite that that misgiving. So, yes, engineer appointed by the employer, the dispute avoidance and adjudication board appointed by the parties. If the parties cannot agree, if it's a FIDIC contract, which is the most popular in this part of the world, then the FIDIC president appoints that board in consultation with the parties. I don't know how many Ugandans are on that FIDIC president's list, but certainly a very small number, probably less than 10, plus or minus 5. So yes, then arbitration, which we shall come to later, again, depending on what the contract says, will take off after, in case the dispute avoidance and adjudication board decision has been challenged by one of the parties. Thank you.
Thank you very much, Ivan. Yes, thank you for taking us through the process with which FIDIC contracts appoint dispute resolvers and the process with which disputes are resolved within those forms of contracts. Sticking with you, Ivan, how long is the term for the dispute resolvers? How long are they valid, if effectual? You've said, yes, they're appointed and they are able to resolve disputes, but are they dispute resolvers in perpetuity? Please share some more light on that. Thank you.
Yeah, thank you. As I said, quoting Lord Denning, cash flow is the lifeblood of construction projects. Other people say cash flow is king. That's one thing. Second thing is you're looking at, by all means, an efficient delivery of the project in the shortest time possible and within time and within budget. So to achieve that, the dispute resolution mechanisms exist to guarantee economy and efficiency of the construction project. How do they achieve that? They achieve that by giving the different layers of dispute resolution that I have given in the pyramid very strict timeframes within which to have a matter disposed of. The engineer, for example, will have, say, 28 days within which to have delivered the decision. The same will apply to the dispute avoidance and adjudication board. And in arbitration, a bit of dicey one there, because depending on the rules and which arbitration institution you are operating under, the timelines might be a bit flexible. So the strictness of the timelines is really between the engineer and the adjudication process. My honest view is that when it comes to arbitration, those timelines are not as, well, they're not as strict, let me put it that way. Because there's so many things moving, because the line between arbitration and litigation can be very thin, depending on how the parties behave. I have taken part in an arbitration under the International Chamber of Commerce, which is ongoing. So I wouldn't want to delve much into the details, but we commenced arbitration in the year 2024. I'm giving this example just to demonstrate how these timelines can be very fluid. First point of dispute was how many arbitrators should resolve this dispute. It's a FIDIC contract. The contract was probably worded in such a way that there was flexibility around the number of arbitrators in such a way that it said one or three, depending on how the parties agree. That meant that there was a difference of opinion between us as the lawyers for the claimant and the lawyers of the respondent. The respondent's lawyers wanted 3 arbitrators because, according to them, it was a complex project. It's a project that is the first of its kind in Uganda. It involves over $25 or $30 million. It's a World Bank funded project. It involves a claimant from Uganda and a respondent from Southern Africa. and therefore that makes it complicated. Our argument was, we don't think it's a complicated project. It's a simple breach of contract dispute, which can be resolved by one arbitrator. Of course, the catch was around cost, because this is arbitration under the International Chamber of Commerce. The cost of having 3 arbitrators was going to be about $500,000. The cost of having one arbitrator, $150,000. So the client whispers to you and says, if we have 3 arbitrators, it's game over, we're done. So put up a fight and persuade the International Court of Arbitration to appoint one arbitrator, since the contract was vague on that. So the International Court of Arbitration writes to the parties and says, make your submissions on why you want 3 and not one arbitrator. So we have to make submissions, and then the court has to make a decision. Luckily, the court agreed with us that one arbitrator could resolve the dispute. Part of it was a poor man's argument to say that international arbitration should not be reserved for the rich, and where one party is seen to be playing or swiping the card of, I've got deeper pockets than you, let me make this more complicated by raising the stakes so that you back off, then there would not be commercial justice. I'm glad that the court agreed with us on that. Now, between commencement of arbitration and the court determining that question, already 5 months have been lost. So the arbitrator is appointed. I mean, it's supposed to be appointed, and the court gives the parties the opportunity to appoint an arbitrator. The other party appoints an arbitrator from a country near them. We proposed Chief Justice Pat Katurebe as a sole arbitrator. We kind of couldn't agree, because now the arbitration had been taken over by a law firm outside Uganda, which probably has a different opinion on Ugandan professionals and that kind of thing, whatever their biases. So now we throw it back to the court to be the one to determine who the arbitrator shall be, because the parties have failed to agree. The court now has, that's another 3 months lost, probably even 4 months. The court appoints an arbitrator from a neighboring country. That arbitrator starts work, and in the middle of the arbitral proceedings, the other party raises what is called an Article 12 challenge, which under the International Chamber of Commerce Arbitration Rules 2021 is an opportunity for a party to file an application to have an arbitrator removed. What does that mean? It means the arbitrator and the claimant now have to file submissions to respond to the challenge to have the arbitrator removed. One of the arguments was this arbitrator comes from a country near Uganda, and therefore we don't think that the arbitrator will be fair, balanced, and objective. We propose that the next arbitrator should be appointed from the United Kingdom or a country in the European Union. We welcome that challenge and put up voluminous submissions, I think going up to 1,000 pages, between 100 pages of submissions, 900 pages of authorities from both sides, just on the question of whether the arbitrator should be removed, and the question of nationality being one of the sticky points. Now the International Court of Arbitration has to make a decision on whether or not to remove the arbitrator. Another 3 months down the road, you're almost in second year, you've not yet gotten into the actual dispute. This is the longest foreplay ever. So, bottom line, 2 years down the road, you've not yet gotten to the real action. So there's a certain fluid nature of arbitration, and of course, people don't usually like to open up about this, because arbitration is packaged as this nice, sweet, sexy, awesome, lovely dispute resolution mechanism, which is fast and efficient. Sometimes it is, sometimes it could be messy, as I've demonstrated there. Oh, well, maybe last, in the interest of time, then after the arbitrator is preserved by the court, in other words, the application to have the arbitrator removed is dismissed, the next challenge is the arbitrator lacks jurisdiction. And now the arbitrator has to make a decision on whether or not he or she has jurisdiction. Again, about 200 pages of submissions from the other side, about 900 pages of authorities to show that the arbitrator doesn't have jurisdiction in this matter. We also have to now burn the midnight candle and put in about 100 pages of submissions. The arbitrator has to deal with all this and make a decision. The beauty with the ICC arbitration rules is that there are timelines within which the arbitrator has to make that decision. Challenge with that is on paper, that sounds fascinating. In real life, as I've demonstrated, so many things can happen. In the middle of an arbitrator delivering a procedural order for parties to file submissions on jurisdiction, someone challenges the arbitrator and wants the arbitrator removed. And then the matter now has to, if it's a CISO, the weight now has to shift to the International Court of Arbitration to determine whether the arbitrator should be removed or not. So these moving targets really complicate the timelines, and that's why, however well-meaning it is for the arbitral institutions such as the ICC or the London Court of International Arbitration to have strict timelines, sometimes it can be very difficult and almost impossible to operate within those timelines. Yeah. Thank you.
Thank you so much. You have taken us through the process of the dispute and some of the challenges, and given us examples that you are involved in. We'd like to discuss a little bit about what happens. You have actually gone through the process of dispute resolution, and the arbitrator has actually, the arbitrator has actually given an award. I would like Anne to help us to tell us how does the winning party effect an award given to them? How do they enforce the published award? Anne?
Thank you, Philip. I just want to build on something small that Ivan said. Ivan has just given you a masterclass in why arbitration should be a remedy of last resort. Because, as he said, it's lots of work. But I just wanted to put a qualifier that even though arbitration may take long, and sometimes it does not, it is still more desirable than litigation. Because litigation, as we all know, or many of the lawyers on call, is that it will take years and so many other things will happen. And then there is no finality in litigation. In arbitration, as I'm going to discuss shortly, there is the principle of finality, meaning the decision of the arbitrator is final and it is binding. But in litigation, the parties can go up to the Supreme Court. Relationships have been destroyed. Lots of time has been spent. The project has stalled. Taxpayers' money has been wasted. And remember, we said this project is for the common good of 2 or more countries, and nothing has been achieved for the masses. So even though arbitration may seem to be lots of work and takes lots of time, it is still a more preferred course of action to litigation. The only thing the parties need to do is to ensure that in their multi-tiered dispute resolution clause, it's a remedy of last resort. When mediation has failed, when negotiations have failed, when the DAB has failed to act, that is when arbitration should be resorted to. So Philip, you asked about what happens when there's an award. So the arbitrators have been appointed, they have rendered their award. And now, remember, this is international arbitration. So just to distinguish the two, in international arbitration, you present the award to a particular country for enforcement. If a party is dissatisfied with an award, the seat of the arbitration shall be the one to hear the challenge of a dissatisfied party. The seat is not the chair or the venue. The seat is the juridical law governing the arbitration. So they are the only ones who can set aside an application, an award. We had a case in Uganda, Great Lakes, one of the Great Lakes cases, where the seat was London, but they brought it to Uganda to set it aside. And the court said no, because they are not vested with the power of setting it aside because Uganda was not the seat, London was the seat. So question should be had when you're drafting your dispute resolution clause, especially the arbitration part. Be wary of what you provide as a seat, the rules and all those things, because they'll later on come to haunt you and bind you. So London, it had to be sent back to London to hear the application for setting aside. So assuming all this has been done, the seat has upheld the award, it has not set it aside. Then what happens? A party has an award and they want to enforce it. I like taking you back to the beginning because this is where all the problems are solved. When the parties are still in their honeymoon stage and wondering whether the project is feasible, like I said, that is the time to talk about arbitration. So how do you enforce? You should be able to know at that time, before you enter a contract, that there are some countries that will not enforce your award. Even though the seat has upheld the award, some countries may not be able to enforce it. For example, countries that are not signatory to the New York Convention that Ivan mentioned, you may have a problem enforcing your award. Secondly, what is the nature of the dispute? The country may be a signatory to the New York Convention, but it is against their public policy to enforce your award. Maybe, for example, it's a Muslim country and the award relates to alcohol, something else. Dubai will not enforce it, or any other Muslim country will not enforce it, notwithstanding that they are a party to the New York Convention. So all these things have to happen from the beginning. You have to dot all your I's and cross all the T's in the beginning, such that you don't have a moot award. You have one, but you can't enforce because of different reasons. So assuming everything is okay, you chose an international arbitration, and now it's time for enforcing. And the enforcing country is part of the New York, is a signatory to the New York Convention. The New York Convention, to put it in context, is the model law for international enforcement of international arbitration awards. And Article 5 of that convention is the guiding law on enforcement of international arbitration awards. And it says that the state that receives the award should be able to enforce it. Is it cast in stone? No. There are limited grounds where a state may refuse to enforce an award. If it's, like I said, if it's contrary to their public policy, if due process was not followed, for example, the arbitration Ivan is talked about, imagine that he proceeded ex parte without giving notice to the other people, and then he brings an award to Uganda for enforcement. He proceeded in Botswana, brought it to Uganda for enforcement, and the aggrieved party says, but I didn't know. So under Article 5 of the New York Convention, the award will not be enforced. So the grounds for refusal to enforce an award are very limited, and they're in Article 5 of the New York Convention. So to answer your question, Philip, a party who is satisfied with an award, with an international arbitration award, presents it under the New York Convention, assuming the other parties are signatory, the other countries are signatory, and they enforce it. If, for example, it's presented in Uganda, let me use our Arbitration Act Cap 5. It is enforced, and then it is not, the enforcement is upheld. If there's no challenge to the enforcement, then it is enforced. The Arbitration Act says it's enforced in the same way as you enforce a decree of the court. That is how you will enforce this arbitration, international arbitration award. But then again, it depends. It's on a case-by-case basis because, like I said, there are some institutions and organizations that provide for how enforcement is done. For example, under the African Treaty, Continental Free Trade Area Treaty, there is a mode of enforcement. A party who refuses to honor an arbitral award is compelled. They can be compelled by the dispute settlement panel to enforce it, and there are challenge and there are repercussions if that enforcement is not adhered to. But the standard, and that is why you have to very carefully and critically draft your arbitration clause. The standard for enforcement of international arbitration awards is the New York Convention. Thank you.
Thank you so much, Anne, for that elaborate answer, for that expose. I'd like just to touch on one or two issues. You have mentioned that once the award is given, the winning party, using the New York Convention, can enforce it with countries that are signatory to it. In as much as there is a winning party, there is a losing party. So, Ivan, may you just tell us, does the losing party to this award have any redress? Ivan.
Yeah, thank you, Philip. Do you want me to tell you what you want to hear, or a more practical outlook to how sometimes these things play out? So, what you call a losing party? Okay, let me first start by what people would want to hear. The losing party, unless he has grounds that fall within what Anna has described. In other words, these are grounds that the Arbitration Act of the country, in the case of Uganda, public policy, the fairness or lack of independence of the arbitrator could come into the picture. So within the confines of what the statute provides for, you have room to wriggle around that and challenge the award and have it set aside. Sometimes, that's case in point is there's a decision, again, no need to go to the names of the parties out of respect for colleagues, but there's a decision where a Ugandan arbitrator sat and delivered an award. So the losing party on the other side probably didn't expect to lose and realizes, okay, what trick can we pull? So they do research on the arbitrator and find that this arbitrator had undertaken their clerkship as a student at the Law Development Center from one of the law firms, one of the top 5 law firms in Uganda. And they're saying, okay, so the arbitrator did his clerkship at LDC from law firm X. Law firm X is the one that represented the claimant, and the claimant was successful. Without touching the substance of the award or even the form of it, they simply went for the fact that the arbitrator had not disclosed a potential conflict of interest. So typically what an arbitrator ought to do when they're appointed is to disclose that you have no conflict of interest whatsoever in terms of the relationship between you and the parties. But if you have done anything in the past that might give cause to one of the parties to be uncomfortable with your appointment as an arbitrator, it is only professional, ethical, and an act of integrity for you to disclose that fact, and then you leave it to the parties. I'll give an example. In an arbitration where I was involved as counsel against a government entity and a contractor, we appointed Justice Pat Katurebe as arbitrator. I'm giving this an example because I know he won't get annoyed, but also it's in good faith. So Chief Justice Pat Katurebe is appointed as arbitrator. The Attorney General's Chambers agrees with us. The government entity had been represented by a law firm, Otters Advocates, where Justice Pat Katurebe's son, Bernard, a very nice guy, happens to be one of the partners. So what the Chief Justice, and you can trust Mr. Katurebe's professionalism, Hello.
Please proceed, Ivan. We can hear you.
Oh, yeah, thank you. So the Chief Justice made it known to the parties that the law firm which had previously represented this government institution is a law firm where his son happens to be a partner. And So I brief my client and tell him, are you okay with it? He says, yeah, I don't think the Chief Justice would be compromised by the fact that his son had worked in a law firm which had previously represented the other party. So we wrote back to ICAMEC and informed them that we appreciate the disclosure and we have absolutely no problem whatsoever as the claimant with the fact that this government institution had once been represented in the same matter before the Attorney General's Chambers took over by a law firm where the arbitrator's son happens to be a partner. Of course, there are very few Ugandans. We have an integrity deficit in this part of the world. There are very few Ugandans. You can count them on your fingertips who can have those levels of integrity where the party says, I don't care if your son happens to have been a partner in the law firm that previously represented the respondent. I think that you're a straight man and we shall still give you the benefit of not just the benefit of the doubt, but we trust that you'll do a good job. Of course, he didn't later become the arbitrator in that matter because by the time the parties became ready, he had become busy and was not available for the arbitration. So if you contrast that with the example that I've given of the arbitrator worked with one of the top 5 law firms as a clerkship student, but did not disclose that fact to the parties, you will realize that what killed, quote unquote, killed the arbitral award for this successful claimant was just the fact that the arbitrator should have disclosed his potential conflict of interest, because it's a bias or conflict of interest can be perceived. It doesn't have to be real. So as an arbitrator, you've got to be very crystal clear on any potential sources of perceived bias and leave it to the parties and let the parties pronounce themselves, because then the parties cannot use that against you after the word has been delivered. So the consequence for the successful claimant is that you had an arbitrator probably not alive to these dynamics. And that's why it matters whom you appoint as an arbitrator in these things. You could win $5 million and you lose all that money in a successful award because the arbitrator did something sloppy like that. So does that answer the question on what a losing party can do? Yes. Another example of a losing party is the example that Council Anne has given of Zabo again, because this is a matter that went up to the High Court on public policy now. The other one was on fairness, lack of independence. On public policy, you have a London Court of International Arbitration Tribunal sitting and delivering an award. And one of the remedies granted to the successful claimant was an order for transfer of shares in a company between the claimant and the respondent. Of course, again, this is a challenge of arbitration. Sometimes arbitrators might be the smartest people in the world, but they may not be alive to the jurisdictional dynamics at play. What the white man sitting in London in that arbitral tribunal ought to have been advised is that under Uganda's Electricity Act, you cannot transfer a license in a power project or in a company pursuing a power project without express authorization from the Electricity Regulatory Authority. It is so serious an obligation that I have a license, for example, for a hydropower project. I can't even transfer 2% shares, 1% shares to Philip, however much I love you, and I want to give you shares in that company. To the extent that I have a permit from ERA without notifying ERA, ERA has to publish in the Gazette and in the national newspaper. Ivan's company wants to transfer 1% shares to Philip. That allows the public to make comments on whether that transfer should be allowed or not. And after the 30 days have expired, then the management of ERA takes that application to the authority, or what you'd call the board, for approval. And then you can be allowed to transfer your shares. So this is a very slippery area because it goes against the conventions of company law. Ordinarily, the directors of the company would sit and say, we've transferred 1% shares to Philip. Under the Electricity Act, you can't do that. I don't want to get into the details because this is not an energy law discussion, but the reasons why the government does, the law is structured in such a way. So this arbitrator makes an order for one of the parties between the respondent and the claimant to transfer shares to the other. So the losing party realizes, wait a minute, we've got a very serious loophole here. Under the Electricity Act, you cannot transfer shares in a company which has been licensed to develop an energy project without authorization from the Electricity Regulatory Authority. Therefore, it goes against public policy to the extent that it is illegal in Uganda for you to transfer shares without ERA's express permission and clearance. And that single miscalculation on the part of the arbitrator could as well have killed, quote unquote, killed an arbitral award where someone was awarded millions of dollars. And luckily, Justice Mubiru, being the sober judge he is, decided to do what in law is called to sever. In other words, you allow all the other remedies that have been granted by the tribunal to the extent that they don't offend public policy. And then this one remedy that contravenes the Electricity Act of Uganda, you sever. You shoot it down, and therefore the 98% of the arbitral award remains intact, and then this 2% which taints it is then disinfected by court order to the effect that the claimant or respondent should not implement it. So again, that shows you what kind of options there are for losing parties. We operating within the law, public policy, fairness, and independence, and those kind of considerations. In 1 minute now, that is a good and good side and nice side of it. The crooked and crazy way sometimes that happens in Kampala, but also other places, is to say, okay, we don't think we shall win on public policy because there's no ground. We don't think we shall win on fairness, procedural regularity, independence, or lack thereof. So what do? You just find anything stupid to say, and you throw it to the court. I won't give examples out of respect for senior colleagues, but I would have given examples of cases in the courts of law that are playing out like this. So someone gets an award from France or Mauritius or South Africa or the UK, comes with the award, they've been awarded $65 million or $40 million. So the clever lawyer in Kampala files some application to have it set it aside with all sorts of crazy grounds. And the High Court will dismiss it to the extent that it doesn't fall within the grounds provided for in the Arbitration Act. What does the lawyer do? You go to the Court of Appeal, well aware that you have authorities, Babcon versus Mbale Resort, that went up to the Supreme Court, and several others, the Aya Investments case, that make the intervention of Court of Appeal and the Supreme Court practically almost impossible in these circumstances. But the lawyers again files this application. Appeals the Court of Appeal, well aware that the appeal will be dismissed by reference to the Babcon case, and then probably even lose, and then go to Supreme Court, well aware that the Supreme Court will dismiss. What is the lawyer trying to do? To buy time for a client who is just trying to be mischievous, dishonest, and unscrupulous. In that period, he's possibly knowing Uganda's case backlog system. You could buy a client 10 years. It's not a professional way to do things, but it happens. I'm only sharing it because it's a reality of our market, and to really say we can do better, especially if we want to foster a culture of arbitration in commercial dispute resolution, and to make this country a desirable mechanism for a desirable seat for arbitration. Sometimes there are extreme cases which I don't want to give. I've seen cases where someone writes to the principal judge calls for the file. This is a matter under arbitration. Someone has applied for an interim measure of protection. The losing party engages the principal judge because they're politically connected. There's one where, anyway, let me not get into that, but Kampala really gets messy with these things. So there's what the law says and what looks good on the paper, and then there's the real dark arts of litigation in Kampala, and can get really messy.
Thank you, Ivan. we want to stay with you for our next question. You've painted a picture on what happens in the arbitration space in Uganda. We have recently heard that Uganda won an RVR, or Rift Valley Railway arbitration dispute. In light of our topic today, may you give us the highlights of this dispute and possible lessons that we can learn moving forward when engaging in these type of contracts?
Yeah, thank you, Philip. So a company called Rift Valley Railways a few years ago was contracted or entered into contract with the government of Uganda and the government of Kenya to basically enter into a railway concession agreement let's say concession agreement sometime in 2006. This company's obligations included, among others, improving our railway services, such as the freight transportation, maintaining the railway assets, in which, and in return, the government of Uganda, through the Uganda Railways Corporation, would get about 11.1% of gross income from that concession, from the concession fees. Along the way, as sometimes happens in big contracts like this, there was underperformance of obligations by the claimant, in this case Rift Valley Railways. There were issues around breach of contract, which the government of Uganda and the Kenya kept raising to this concessionaire. The concessionaire, for whatever reason, probably had a different opinion on project performance and contract performance and progress. Long story cut short, the concessionaire then in April 2020 commenced arbitration at the London Court of International Arbitration, claiming compensation for $2.3 billion, about 8.2 trillion shillings. Part of the argument saying now Uganda is moving to, Kenya and Uganda moving to have a standard gauge railway. They're moving away from the meter gauge railway system. This has adverse impact on our contract or project and so many other claims. The London Court of International Arbitration dismissed the claim. In other words, Uganda and Kenya won. Uganda was represented by law firms from the UK and K&K from here, and yeah, so it was a good day, because as taxpayers, at least we got a saving thanks to a good job of the lawyers on both sides of the border, Kenya and Uganda. And Rift Valley Railways case was dismissed. What are the lessons? One, of course, as you can see, I mentioned the law firm that represented Uganda. For a reason, local context is very important. However smart the international lawyers are, they might be the best law firms in the world. You always need that local content, that local input. So more often than not, it helps to have in these complex projects a local law firm or local lawyers on the team. You'll notice that the example that I gave earlier of the London Court of International Arbitration Tribunal sitting and making orders, and the Muzungu man did not know that Uganda's Electricity Act does not allow what he was ordering for, can have very serious consequences. If you find a judge who is ruthless, the entire world could collapse. If you're lucky to find a judge like Justice Mubiru who says, okay, let's siva, that's a good day for you. So that local context cannot be over emphasized. The other lesson, of course, is, and I think in terms of the overall picture, it's fascinating how the entire African continent has not built capacity to have disputes of this magnitude being resolved within Africa. So we always have to have recourse to London Court of International Arbitration, the International Chamber of Commerce, which in 2023, I was reading the report, had about 900 cases from different parts of the world. So I think that there is a case, this is a political discussion, for African countries to build this capacity, because we are exporting a lot of money to the British, the French, British for the London Court of International Arbitration, the French for ICC, sometimes the Asians, if it's Singapore or Hong Kong, sometimes the Swedish with that center. So it's, I mean, for me as a practitioner in this field, it's something I find fascinating that in a matter where I'm involved at the ICC, one of the arguments from a law firm outside Uganda was that the arbitrator should be removed because that arbitrator comes from a country near Uganda, and the next arbitrator should be appointed from the EU and or the United Kingdom. Of course, we took issue with that, and since they had decided to become petty, we said, okay, let's meet you at the pigsty and give you a dose of your own medicine. So we said, okay, let's now swipe the race card and sexism. We said the only reason why you're making a case for the arbitrator to be removed and be replaced by someone from the EU or London is because she's a woman, number one. Number two, because she is a Black person, and these are white people representing the respondent, and therefore we respectfully think that the arbitral institution should take very seriously the sexism and racism innuendos that are laden in this type of arguments. It was a mischievous thing, but it gave us victory anyway. There were other grounds, but that was one of the controversial issues. Of course, they were very offended, wrote tough letters to the Secretary General and felt insulted. But we had our day. But I think the bottom line is there's room for us. We as African people, as Black people, can do better. We can't be running to colonialists and grandchildren of colonialists to be resolving disputes between us, and sometimes parties are Black. In the case I'm giving you, my client is from Uganda, the other client is from another African country. So Black people have to go to France to have a dispute of what? 30 billion shillings resolved. There, something is just not right. But those are high-level policy conversations, African Union, East African Community, and that kind of thing. Yeah, but I think the RFBR and Uganda-Kenya case, and many others really demonstrates that. Yeah, thank you.
Thank you so much, Ivan. Thank you. Before we get into the last part of our discussion, we have been keeping some participants who have been with us listening, and some of them have questions which they would like to answer. And would like to take this opportunity to address the questions that have been shared with us in the chat. So I will maybe give 1, 2, 3 questions, have them answered, and then come back to you to address them. So question, sorry, just give me a second. Question one, if I engage construction experts from Kenya or Tanzania to construct my residential or commercial building, is that considered as a cross-border contract as well? This is from Damba Hakim. Speakers, if you could just note down the questions and answer, I'll give them in threes, then we'll address them. So that is a question from Damba Hakim. Vincent Bitature Ntongore says, history has it that Cecil Rhodes planned to build a railway and Trans-African North Road from Cape Town to Cairo. This would have been transbordering. transboundary construction project. This project would have entailed different legal regimes and therefore international arbitration. This is information for us. Gulam Dastagir says, FIDIC 2017 edition, if DAAB is not constituted after signing of contract agreement due to one party non-compliance, does it allow the parties to skip DAAB and proceed for arbitration? I'd like us to address these first three questions and then move on to others. Panelists?
Thank you,
Philip. Anne can go first.
Sorry, let me start with let me answer Gulam's question. Gulam asks that if DAAB is not constituted after signing of contract agreement due to one party non-compliance, does it allow the parties to skip DAAB and proceed for arbitration? Your answer is in the clause 21.8. This is now the FIDIC Red Book, but these clauses at least mirror each other, most of them, especially this one on dispute resolution. So the answer is in clause 21.8. And it says that if a dispute arises and there is no DAAB in place or no DAAB is being constituted, then arbitration shall not, the DAAB shall not sit and the parties may go straight to arbitration. So there should be the existence of one of two things. Either there is a DAAB in place with full powers, because you don't want a DAAB whose term of office has expired. Either there is a DAAB in place or a DAAB is going to be constituted. If you're in one of those scenarios, then you cannot skip the process. But in the event that there is no DAAB in place and that there is none going to be constituted, or there is one whose term of office has expired, then you're not bound by any of the clauses of clause 28 of the FIDIC Conditions of Contract 2017 in respect to DAABs. You then may go straight to arbitration. But just to add on something, on that part of if a DAAB is being constituted, like I said, a DAAB will only make sense if it is constituted from the beginning of the project to nip disputes, but to also understand the entire project and be able to give a quick solution. Because if you are constituting a DAAB when a dispute has arisen, make no mistake, that will not be an adjudication. It will be more of an arbitration, because these are new parties. They are new to the project. They don't know anything that has happened in the project. So they are starting afresh, and yet FIDIC requires them to give a decision in 84 days unless the parties agree to an extension of time. So the ideal thing to do is to constitute it at commencement. So to answer your question, the parties can only skip the DAAB if it is not constituted, or if the term of office has expired, but in no other event can you skip. So yes, you can constitute it after signing of contract. Yes, you can constitute it when the dispute has arisen. No, it is not desirable, but that does not stop the DAAB from going on. Thank you. There was the other question, Ivan answered it, question 1, and he can further guide on it. Was there another question, Philip? There were 2 questions, yes? You said we take 3. Let me take another one of Gulam, then I will pass on question number 1 to Ivan. So Gulam asks and says, arbitration, FIDIC 2017, arbitration clause lacks seat of arbitration. Then how to resolve this dispute? This is curable. This is curable because, like I said in the beginning, most of these dispute resolution clauses are haphazardly drafted. So you'll find a very bare arbitration clause. It should not be confused with pathological. Pathological arbitration clause is one that is not final. The one that says that if arbitration fails, then we go to court. Extremely pathological, because arbitration by its nature is final and binding. But that doesn't mean that it's not curable. The parties can cure it by agreement. But one which is bare, for example, it lacks a seat, like most of us draft, we say, if any dispute arises, it shall be resolved according to the Arbitration and Conciliation Act, or it shall be resolved according to the laws governing arbitration in Uganda. There's nothing to do with seat, but the parties, because they have the same mindset, arbitration. When they sit before the arbitrator in what we call the preliminary meeting, they can cure this by agreeing on what the seat of the arbitration shall be. So this is curable. Gulam, to answer your questions, in the preliminary meeting, the parties agree on which seat to have. Of course, it's desirable to draft it well, because the parties may now pull ropes on that part. And like Ivan said, there might be a lot of rope pulling, but that is because of a badly drafted clause most times. So in the event that you don't have it in your clause, the parties can agree during the preliminary meeting and agree on what the seat shall be. That is curable, and that is how it's resolved. Thank you, Philip.
Thank you, Anne. Ivan, if you could answer the
thank
question.
you, Mr. Damba, on whether a residential house with people coming from Kenya and Tanzania in Uganda to build qualifies as an international construction contract or cross-border. It really depends, but I think that what makes a construction contract international, or a contract where you have the factors of production crossing borders, in other words, the borders are not physical geographical borders, but factors of production moving, is largely dependent on, among other things, its ticket size, complexity. I don't know what would be complex about a residential house, even if it's state house. It's a very basic structure. The last time I checked, there's nothing complex about it. Maybe security installations coming from Chinese, but you can do that on the basis of a very basic contract from PPDA with a Chinese supplier to come and install security systems. Unless you're doing something as big as the kind of buildings that we see in the US, where someone has a residential house like Jeffrey Epstein, the American controversial man, had $70 million somewhere in New York. But the cost could be $70 million, which is the value of Epstein's property in New York, but not necessarily complex. Complex in the sense that you have different nationalities coming into the picture because of the inherent nature of the project. The example I gave was Mulago and Nagoro. Ministry of Health doing both projects. The other one is a domestic construction contract. The other one is international, because A, you have an international contractor. B, you have an international funder or source of finance for the project. B, you have a dispute avoidance and adjudication board drawn from outside the country of the employer and the contractor. D, you probably, of course, it's a project of over 100 billion shillings. And then you have suppliers and subcontractors and everyone in that value chain being drawn from probably another 3 countries, given the complexity of having a world-class heart treatment facility. So that's what would make it. And then, of course, you have the contract governing is FIDIC. So your residential house in Nigeria, which you give to Rocco, or I don't know which other contractor, and the contractor brings some Juakali chaps from Tanzania and Kenya. The fact that you have workers coming from Kenya and Tanzania to join the project, they could even come from Mexico, wouldn't make it international. Thank you.
Thank you, Ivan. Thank you, Anne, for answering those questions. I'd like to move on to the questions which were raised by Mwesigo Caleb. One, and then there's another one from anonymous attendee. Question 1, he says, what happens if the contract does not have a dispute resolution clause? What are the options taken here? 2, I have seen some scenarios where the clients delay payments or totally refuse to pay contractors, even after project completion. In this situation, how do I protect myself from clients? Thank you. So that is from Mwesigwa Caleb, and just from the anonymous attendee, specifically to Anne. is arbitration really desirable when there is a rising trend of parties challenging arbitral awards in the High Court, setting in motion litigation? So maybe I'll ask Ivan to address the questions from Mercy Kalib, and then and do the question from anonymous attendee. Thank you.
Okay, thank you. The question on the contract has no dispute resolution clause. Of course, for drafting, the bit about arbitration, though, is that it's by the agreement of the parties. The parties can enter into an arbitration agreement, even in a contract that doesn't have an arbitration agreement, once the dispute has erupted. In other words, if for whatever reason you went to a law firm and the lawyer forgot to add that dispute resolution clause, a dispute has arisen, the two of you can agree to refer the matter to arbitration, ad hoc arbitration, and appoint an arbitrator. So in other words, it's not cast in stone that you can only do arbitration where the contract has provided for arbitration. You can have arbitration as an agreement that the parties agree to or arrive at after the contract has had some disputes arise. In extreme cases, there's a phenomenon called non-signatories in arbitration, which goes against the conventions of international commercial arbitration and different statutes around the world on arbitration, because ideally the rule of thumb is the parties must have agreed to refer the dispute to arbitration. What happens if you have a situation where a dispute arises and one of the parties seeks to enjoin or bring into the arbitration mix or ring a party that has no arbitration agreement with it? I've handled the matter at the International Chamber of Commerce where that such a thing played out. You have a contractor who signs a contract with Philip Limited, but Kaheru Limited happens to be a parent company of Philip Limited. And now the contract is, at least in writing, is between Philip Limited and this contractor. The contractor looks around and says, wait a minute, if I don't bring Kaheru Limited, which is the parent company with the money, this Philip Limited, the one that I signed the contract with, which has an arbitration agreement, that is the one I'm supposed to be doing arbitration with ordinarily, is a shell. It doesn't have money. So I would be wasting my time. I need to do everything possible to bring Kaheru Limited into this arbitration. In other words, make it, join it into the arbitration. The first protest from Kaheru Limited will be, I have no arbitration agreement with you. I don't know you. I have no contract with you. You're a stranger. Yeah, so I've dealt with that kind of situation. It played out in the High Court here. I can share the names of the parties because it's published in the law reports at ULI. Plinth Consultancy Services Limited versus Inyasi Construction Limited. Inyasi from Eswatini, or what used to be called Kingdom of Swaziland, gets a contract with the government of Uganda. Then its subsidiary in Uganda signs a contract with Plinth Consultancy Services Limited, but Inyasi Construction Limited, the Eswatini company, is not mentioned in that contract and doesn't sign that contract, that subcontract agreement. But remember, it's Inyasi Eswatini that has the main contract with the government of Uganda. Throughout contract performance, right from issuance of the commencement order, site possession certificate, and payments made and certifying of payment certificates, the entire contractual relationship was with the parent company and not with the subsidiary that signed the contract. So in other words, at contract performance, the subsidiary vanishes off the contract scene, and then you are now left with the parent company. Question then is, can you bring the parent company into the arbitration in light of what the Arbitration Act provides for, and what is called the in-writing requirement under the new convention that parties must have agreed to, in writing, to have arbitration between them as a dispute resolution mechanism of choice. It became contentious because at one point we needed to secure what is provided for in the Arbitration Act, interim measures of protection. In other words, as the arbitration is pending before the arbitral matter is disposed of, the High Court of Uganda has powers under the Arbitration Act to give you interim measures of protection. The first preliminary objection was, we don't know these people. We have no contract with them. We have no arbitration agreement with them. But there's lots of material and jurisprudence on how you can join a non-signatory to an arbitration. It was actually my master's degree thesis at Robert Gordon University. Joined of non-signatories in arbitration in the UK, Uganda, and India were my case studies. So, in other words, you have a contractual relationship, pure and undeniable. But the party says, I have no arbitration agreement with you, despite the fact that the conduct of the parties points to a valid contract. Whether you can join that party or not can be a very, very tough war, I can tell you. But there's lots of jurisprudence that has emerged now that makes that possible. And in that particular case, the High Court of Uganda allowed for the joinder of that parent company and agreed with us that the arguments for joinder of non-signatories were applicable, as, of course, there's a lot of controversy that eventually happened, which I don't want to get into. But yes, the point is that you can have arbitration agreed to by the parties after the dispute has erupted, even if it was not provided for. In other words, you enter into a new contract, this time around for the dispute resolution. Then the question on challenging arbitral awards, should we still do arbitration? I think arbitration is still a great thing to do. Challenging arbitral awards is not a bad thing. There's a reason why across the world, whether you're looking at the United Nations Commission on International Trade law, provisions on what's called the model law or the NEO Convention, there's a reason why across the world there's a provision for an arbitral award to be challenged, because we are dealing with human beings. As Karl Popper, the great philosopher, put it, the nature of human society is that it is inherently imperfect, but capable of perfection. So you don't want to have a party left without recourse in an arbitration, for example, where an arbitrator was biased or lacked independence. Or you don't want to have an arbitral award which was delivered with outright disregard for public policy considerations or the laws of the country. In the Arab world, for example, the Muslim world, there are certain things that an arbitrator cannot do. There are certain remedies you cannot grant, which go against Sharia law. Those are very serious legal and policy arguments to justify why there should be legroom for arbitral awards to be set aside if they offend those principles. So, but also to really say that the fact that sometimes, as happens in Uganda, where we have a lot of unprofessional conduct, like I gave an example of, you go to the Court of Appeal, Supreme Court, just to buy 10 years of time and defeat the fruits of an arbitral award being your ultimate goal. That, I think, in Africa, we say you don't throw the baby with the bathwater. It shouldn't dampen the mood. It shouldn't discourage us. There will always be some black sheep in the flock. And I think the solution to that is for us as professionals in this field, but also for government and all stakeholders, to try as much as possible to keep improving our jurisprudence and our laws to reduce instances like that. You have a Supreme Court decision that limits the intervention of court in arbitration matters, but you still have the Supreme Court entertaining arbitral awards, and judges, for example, in the Court of Appeal in one case, issuing injunctions in matters in arbitration pending the disposal of the main case or the appeal, and the judge is probably corrupted or compromised, and he has been told, just give me an injunction, I want to buy time. These things happen in this city, and it's not a good thing. But tonight, I don't think we came here to discuss the ethical dilemmas around arbitration in Uganda. Thank you.
Thank you, Ivan. Thank you, Ivan. I'd just like to mention the next three questions, and I'd like maybe Anne to address them. And the first one is, which institutions in Uganda offer studies in Uganda at a professional level? That is from Opio Norbert Achai. From Ruth Rayner, where Ugandan registered companies enter into a contract containing an arbitration clause designating an international forum, does such a clause operate to oust the jurisdiction of Ugandan courts or preclude recourse to domestic arbitration under the laws of Uganda? And then from Solomon Kassa, feeding conditions of contract under subclause 1.4, law and language, usually state the governing law. Accordingly, even if the contract possesses the arbitration clause and seat location, does the law specified under clause 1.4 still be valid? Anne, may you please address those three? Thank you.
Thank you. Thank you, Philip. There's one that from anonymous attendee. I request to start with that.
Oh, yes. Sorry.
So,
Yes.
it's okay. Is arbitration really desirable when there is a rising trend of parties challenging arbitral awards in the High Court setting in motion litigation? Anonymous attendee, as we mentioned, they have, because of the finality of arbitration, there are very limited grounds to set aside an award, or since we're speaking about international arbitration, to refuse the enforcement of an award. So arbitration is still desirable because courts, we need to understand that courts, when faced with a challenge to an arbitral award, are not supposed to open up the award. No, because that would now be an appeal. They are supposed to limit themselves to the procedural aspects, justice, fairness. Justice Mubiru, in several of his decisions, has said you take your arbitrator as you find them. So woe unto you, the parties, if in the beginning you appointed a friend or an acquaintance or a classmate and they give you a decision that you don't agree with, in the absence of it being within the specific scope of Article 5 of the New York Convention, you will live with that award. It will not be, enforcement shall not be denied. To bring it home, Uganda is now, we are projecting ourselves as a preferred seat of arbitration. And one of the key things that point to a preferred seat is a pro-arbitration
.
judiciary. And this is where I would like to commend our courts, especially the Court of Appeal and the Supreme Court have come out very strongly, all the way from Babcon, Bale Resort years ago, to Rocco Hamid, to recently Vantage, where they said that arbitration is final. Arbitration, the court's powers are limited to only as provided for in the arbitration acts of the different seats. So, you will have no court intervention. Vantage was a very interesting one because one of the judicial officers tried to sever the Arbitration Act and the civil procedure, the civil procedure laws, and said that, oh, it was not governed by the Arbitration Act, so the civil procedure laws will apply. But the Court of Appeal very recently strongly came out and quashed that decision and said that from the time of Babcon Supreme Court, court intervention is limited to the grounds provided for in the different seats. So if it's an international arbitration, courts can only intervene as provided for under Article 5. That is where they can refuse to enforce an award. If you don't fall within the grounds of Article 5, there is no help for you. You cannot appeal. In most seats, you can't appeal. In most seats, you cannot review. So it is still desirable. The parties will challenge. We applaud our judiciary for being pro-arbitration. There is no judiciary in the world that is anti-arbitration 100%, because they know these investors, we're talking about cross-border, there is no investor who will want to come to a country where the dispute resolution clause is litigation. So it is still desirable. It will attract investors. It will position the countries as safe seats. And even though you go to court, you have the leeway to go to court. It is not a matter of course that your application shall be upheld. And there's also a timeline within which to bring these applications. In Uganda, it's 30 days from the date you received. It's 1 month from the date you received the award. So past 1 month, there is no one who is going to bend time for you. Remember, you can't even put in an application for extension of time, because remember, court intervention is limited to what is provided for in the different laws. So it's still desirable. It's the most desirable form of alternative dispute resolution as a last resort. OPIO, which institutions in Uganda offer studies in Uganda at a professional level? I would like to think this is in relation to adjudication and arbitration. To be a great arbitrator, you must have the platinum standard. Worldwide, the platinum standard for arbitrators is the one issued by the Chartered Institute of Arbitrators, UK. Now, the Chartered Institute of Arbitrators works through branches and chapters. In Uganda, we have a chapter, the Uganda chapter of the arbitrators, that works closely with the mother branch in Kenya, and they conduct trainings periodically on membership. They offer membership, and when you have a post-nominal of CIAB, you are recognized anywhere in the world. So I would like to urge us to follow the Uganda chapter on LinkedIn, to follow it on X. They have trainings that Pathway, they're called Pathway because they give you a qualification that is recognized anywhere you go in the world. When you are MCIAB or SCIAB or FCIAB, if you're a fellow, a member, an associate, a chartered arbitrator, more often than not, you will be considered for appointments. For construction and adjudication, there are different universities that you can go to. Ivan mentioned some of them: Robert Gordon, King's College. Locally, Construction Law Institute offers courses. We offer different trainings. We offer short courses. And we're happy to report that we're accredited by the Law Council. So this is a training of Construction Law Institute, fully accredited by the Law Council. We're accredited as a service provider, and our trainings are accredited. So follow Construction Law Institute on LinkedIn to keep up to date with the trainings. Follow it on X and keep up to date with the trainings. Follow it on the website, constructionlawinstitute.com. And there is no one who will want to appoint you either as counsel or arbitrator or even as adjudicator if you don't have knowledge of the subject matter. So self-study, put in a lot of, attend trainings and put in a lot of effort. So I would refer you to CIAB Uganda chapter, follow them. Construction Law Institute, follow them. We've been talking about adjudication. Construction Law Institute has a panel of adjudicators. You go to the website, you can choose an adjudicator. In the event that you have a situation where you have a contract without rules, Construction Law Institute came up with rules, adjudication rules, that you can contractually propose to be binding. They're also on the website. Become a member. How to become a member is on the website. Ruth, where Ugandan registered companies enter into a contract containing an arbitration clause designating an international forum, does such a clause operate to oust the jurisdiction of Ugandan courts or preclude recourse to domestic arbitration under the laws of Uganda? We need to, time fails me, but there are different nuances to an arbitration clause. There is the law of the seat, which I explained was a juridical part that will govern the judiciary part of it. For example, which court will you go to set aside? Which court will you go for interim protection measures? Which court will you go to if you need a remedy, like for example, summoning a witness? So that is known as the law of the seat. Then you have the venue, where will the arbitration be carried out? Then you have the law of the contract. What is the law governing the contract? Because we have the seat, but then we have the law governing the contract. Is it governed by the laws of Uganda or is it governed by the laws of London? You can have a scenario where the seat is London, but the contract is subject to the laws of Uganda. you have the rules governing the arbitration. What are the rules governing your arbitration? How is it going to be conducted? Will it be the ICC rules, the CIAB rules, the London Court of International Arbitration rules? What will guide your arbitration? So if you have an international arbitration clause, if you've decided to go the arbitration route, you're not ousting jurisdiction of Ugandan courts. These are two different types of dispute resolution mechanisms. So if you have opted for arbitration, there is nothing the court is going to do for you unless you are presenting it with an application to set aside or challenging anything. And that is dependent on the court of the seat. So it's not ousting as such, but you're bound, parties are bound by contract. Let's not forget freedom of contract that we studied. If the parties agree that an international arbitration clause will apply, then they are bound by that. They cannot now be seen to say, okay, now let's go to court or let's try domestic arbitration, unless of course they amend the contract. Anything short of that, they are bound. Solomon Kasa, FIDIC conditions of contract under subclause 1.4 law and language state the governing law. Accordingly, even if the contract possesses the arbitration clause and seat location, is the law specified under clause 1.4 valid? So when you look at clause 1.4, the FIDIC conditions of contract, it says that the contract shall be governed by the law of the country stated in the contract data, excluding any conflict of law rules. So we're talking about the contract. That's what I was trying to explain earlier, the law of the contract. The law of the contract is different from the law of the arbitration. So the law of the contract could be, because it says it's stated in the contract data, the contract data is an appendix to the FIDIC condition of contract 2017. In 1999, it has another name. So if the contract data states that the law governing the contract is the law of Uganda, it's totally different from an arbitration clause. An arbitration clause is a standalone clause. It can be extrapolated and interpreted alone. It is a contract. We usually call it a contract within a contract. And that's why Ivan said if there are people who are not signatory to the agreement, they can still be bound by the arbitration clause, as he discussed. So the FIDIC 1.4 speaks about the law of the contract. It's different from the law governing the arbitration. It's different from the seat. It's different from the venue. It's different from the arbitration law. So clause 1.4 is valid because it's talking about the law governing the contract, which is different from the law and seat of the arbitration. Thank you, Philip.
Thank you, Anne. Thank you, Ivan, for answering those questions.
Philip.
Yes. If I may.
If you may, with your indulgence.
Yes. Please.
There was a very good question on what happens if there's no dispute resolution clause in the contract. Can I still go to arbitration? I think I wanted to just add something very small. Our parliament, in its wisdom, in legislating the law governing civil procedure in Uganda, actually created a situation where it is possible for parties, even when they're doing litigation, to look each other in the eye and say, wait a minute, maybe we need to get out of court and just do arbitration. I have a ruling of court, Block Technical Services Limited versus Mbarara University of Science and Technology, where the contract had an arbitration agreement, but that arbitration agreement, as undescribed, could potentially be described as pathological. In other words, it doesn't meet the threshold of an arbitration agreement that is valid, binding, and enforceable, in the sense that it is quite vague, too vague to give effect to what can be called binding and enforceable agreement. So when we went to we filed in the High Court. The university said we have no business being in court. There's an arbitration agreement. We had a different opinion on the validity and binding nature of that arbitration agreement. So we said, okay, so if you want arbitration, we can go to arbitration. The university says, okay, we don't mind going to arbitration, but you have to withdraw and pay us costs. We say, no, we can only withdraw and we go to arbitration if there is no cost implication. So you can imagine a very small point of departure just on whether you should withdraw and pay costs it took us 1 year because the matter now had to go to the judge to make a decision on whether an arbitration agreement, so-called, that simply says disputes under this contract shall be resolved under CADA, what used to be called the Center for Alternative Dispute Resolution, now going to the Ministry of Justice and Constitutional Affairs. And Justice Mubiru, in his wisdom, said, I don't think this is an arbitration agreement that is binding, enforceable, and valid. It simply provides for procedure, CADA being where the parties will go to. I don't think that this amounts to an arbitration agreement that can host the jurisdiction of court. Something happened along the way. The principal judge calls for the file, then it's transferred to Mbarara High Court. We now go to the Mbarara High Court, and that same dispute as a preliminary objection arises in the Mbarara High Court. And the judge now has to ask us to make submissions just on that clause. Disputes under this contract shall be resolved under CADA. Is that binding, valid, and enforceable arbitration agreement? Our view was it's not. The other side said it is. Long story cut short, that preliminary objection was dismissed. So the court agreed that indeed the parties were rightly before court. The jurisdiction of court was not ousted by that, what passed for an arbitration agreement. Then first day of mention, the judge asked, so parties, what do you want? Do you still want to fight in court or you want to go to arbitration? We said, okay, now that they've lost the argument on jurisdiction, on the binding bindingness and enforceability of the arbitration agreement, we can as well go to arbitration on our own accord without having to incur costs. So the recourse to that is Order 47, which provides that where in any sort all parties interested, mark the words interested, who are not under disability, agree that any matter in difference between them in the suit shall be referred to arbitration. They may, at any time before judgment, apply to the court for an order of reference. So yes, Justice Joyce Kavuma gave us an order of reference and referred us to ICAMEC, where that arbitration played out. So that is an application you make under the provisions of Order 47. Of course, the nature of that court-referred arbitration is that if the arbitrator operates outside the time frame that has been given to them, that can expose the arbitral to challenge on illegality. So you always have to keep going to court for extension of time in case there is any delay. So I just thought that would be helpful. So parties should take. I encourage especially the lawyers to read Order 47 and the jurisprudence around that. I think the civil procedure rules allow for that flexibility. Thank you.
Thank you so much, Ivan. Thank you so much, Anne. Thank you so much, participants. We really ran out of time, and I would like us to give the speakers an opportunity to give us their parting shots. So at this opportunity, I would like to request Anne and then Ivan to give us their parting shots, but also in light of this question that says, what should we do to ensure or improve dispute resolution in cross-border contracts? Thank you. Anne?
Thank you so much, Philip. Before I answer and give my parting shots, there's a question, just one question we didn't tackle from the audience. It says, what happens from Yvonne? I think it's from Yvonne. What happens when you have a binding adjudication award and the other party cannot pay? It's a very good question because adjudication by its nature, it's binding until the parties, a dissatisfied party goes to arbitration. So it's binding in the interim. So if you have an order and the other party cannot pay, under FIDIC, you can then commence arbitration as the holder of the award or as the winner in the arbitration. You can commence arbitration and ask for the arbitrator to enforce or to declare your award enforceable. So you go, and it's usually expedited. They use what they call expedited arbitration, and they declare your award enforceable, final and binding, because if it's not final and binding, it is not enforceable. In other jurisdictions, for example, in Botswana, it's something different. They have an interesting legal regime in a certain case where this person has an adjudication award and the other party is not doing anything about it. So they went to court and court agreed, and they enforced it as a summary suit. That is Botswana. Interesting jurisprudence there. Okay, I hope I answered that question. My parting shots in light of the question is, what should parties do to ensure smooth execution of cross-border construction contracts? To ensure smooth execution of cross-border construction contracts, one, properly thought out plan at the inception stage, where everything, like I said, is dotted and crossed, and you provide for everything, including for international arbitration. You will provide for DAABs such that if a dispute is to occur, then the DAAB can handle it. But most importantly, the DAAB, the avoidance in the DAB, should be the one to handle the project from the beginning to ensure that disputes are avoided. Another thing the parties can do is to create a coordination committee. We've seen it work in some countries. For example, the bridge that was built connecting Sweden to Denmark. There was a coordination committee that made sure it was smooth. It's a rail and road bridge. So part of it is road and part of it is rail. How they were able to pull through that fantastic over 16 kilometers bridge was through a coordination committee. So have a committee in place. That committee will monitor that the project is moving well. Have a DAB in place from the beginning. Have a strong multi-tiered clause with arbitration being final resort. Provide for negotiations, provide for mediation, provide for everything, but arbitration, let it come at the end. So as a very good dispute resolution clause would have a very strong dispute avoidance and adjudication board as part of the clause. Thank you so much, Ivan. Thank you so much, Philip. Thank you to our dear participants. Thank you for staying on until this time and for keeping us active, alive, and engaged. We look forward to welcoming you in subsequent webinars as organized by Construction Law Institute. Thank you.
Thank you, Anne. Ivan?
Thank you, Philip, for a good job moderating. Someone sent me a message, I think the senior advocate, Christine Birawa, saying you are a very confident moderator, so some kudos for you. But more importantly, to thank our esteemed audience, because without you, we basically wouldn't be here. You're the reason why this is possible. So thank you so much for your patience, for your kind consideration in terms of your time. Parting shots, the complex nature of construction projects, or let me just say infrastructure projects for that matter, is a phenomenon that we can't overemphasize. And the truth of the matter is there can never be a perfect project. There can never be a perfect situation in a human society, because the nature of human beings is that we're infallible, and we're an alloy of good and bad. So there's always bound to be challenges. There's always bound to be disagreements. There's always bound to be disputes. The essence of dispute resolution is to exactly deal with that aspect of and reality of human society. And therefore, alternative dispute resolution is an important tool to achieve that end. I don't want to become academic. There are, theories around legal pluralism, that you can have different laws working in coexistence despite different jurisdictions. There are issues around system design, theory of law, that you have a system of dispute resolution that is tailored for the circumstances of a particular project. And that precisely is, and then of course, efficiency. The theories around economics and law and efficiency. So alternative dispute resolution fits in all those aspects. You can cross borders in terms of different jurisdictions and still be able to resolve a dispute despite differences in legal systems. You can still achieve efficiency, and more importantly, under systems design theory, you have a dispute resolution mechanism that is agreed to by the parties and desirable for the circumstances of the parties, away from litigation, where we know that our courts are already overburdened by case backlog and so many other challenges. So this is something that we need to embrace across the built environment, professional space, engineers, doctors, lawyers, and all the professionals. We need to embrace it, and more importantly, let's not taint it with the bad manners that we bring from litigation. I know of a retired principal judge I recently appointed as an arbitrator. Okay, I nominated as an arbitrator in a matter, and the other counsel agreed that they were comfortable with him as an arbitrator, and they agreed to arbitrator simply said he was not available. When I inquired from his office why he wasn't available, someone very close to him told me he thinks that what is happening to arbitration in Uganda today goes against what the old guard envisioned as the essence of alternative dispute resolution. So you have litigation now being disguised as arbitration. And for that matter, that retired principal judge goes really very slow on arbitrations. So it's not a good thing that by infection, we are spoiling this little baby called alternative dispute resolution in our system by bringing the bad manners from litigation. So I think that as professionals, we ought to look at the big picture. It's good for everyone. And yeah, thank you to everyone who made time for this discussion and to listen to our submissions. Have a good day.
Thank you so much.
Philip, just one thing. This webinar was being live streamed. So on the YouTube channel of CLI, you can listen to it again. You can ask friends to listen in. We're so sorry that at one point we couldn't admit more people because we were full to capacity. But you are able to get this webinar on the YouTube channel of Construction Law Institute. Thank you. Over to you, Philip.
Thank you, Anne.
Oh, Philip, just a second, with your indulgence, if you may. With your indulgence.
1 minute.
Yeah.
Ivan,
there was a question on where to study arbitration from. I don't know, alternative dispute resolution courses and all that. Anne answered that. Just for emphasis, as a parting shot, as professionals in this space, it's important for us to really undertake professional training, because as we say, the more the merrier. We need more competent people. We need more people who understand how these things work. You are a quantity surveyor, but you have been able to hold for 2 hours moderating what ordinarily would pass off a legal discussion, but because you're trained, you're a fellow of the Chartered Institute of Arbitrators, and you're an arbitrator yourself. So I think it goes a long way to emphasize the importance of training and accreditation. And the more people we have who are competent, who are accredited, the better for the industry, including at the bench. Part of the problem is that you have judges who approach arbitration as litigation, and they become a problem because they don't bother to learn these things. But there are many shining examples of judges like Justice Mubirani, Justice Kirawire, and so many others who have embraced training and the importance of accreditation. So yeah, I can't emphasize that enough. Thank you. Kwaheri.
Thank you so much, Ivan. Thank you so much, Anne. Thank you so much to our participants and our listeners all over the globe. Thank you for being such a good audience. Thank you so much for your questions and waiting this long for the answers. We do apologize for those questions that we have not addressed. I will try to see a way in which they could be addressed, maybe on our website. If you could probably keep checking our website, you just might find that we would be able to answer those particular questions that have been raised and not been able to answer them during this time. I would just want to say that education is important, and we're glad that you've been here to learn, maybe grow in the things that you may not have known, but probably also strengthen that which you've already known to affirm that which you know. I'd like to encourage us to also stay in touch with upcoming events. Check our website, check our social media handles on Construction Law Institute, and more especially the international conference being hosted by the Chartered Institute of Arbitrators Uganda chapter that is going to take place on the 13th and 14th of November. The Construction Law Institute is a supporting institution to that event. So please make sure that you are all registered and will be there, because we are looking to learn more about arbitration and ADR. So thank you so much. I've been to you, and thank you so much for hosting us, Construction Law Institute. I've been your moderator, Philip Kaheru. Goodbye. God bless. Thank you.